drafting that will focus on mastering drafting of plaints, written statements, and replications. This pivotal session is led by Advocate Namrata Chandorkar, a proud alumnus of ILS Law College, Pune. Namrata brings over 4 years of rich hands-on experience in high-stake litigation. She regularly appears before some of India's most critical judicial forums, including National Consumer Dispute Redressal Commission, the National Company Law Tribunals, the Delhi High Court, and the Supreme Court of India. In this session, Advocate Namrata Chandorkar ma'am will guide us through the critical aspects of drafting plaints and written statements, shedding light on their complexities and how to navigate through them with ease. Without further ado, I request ma'am to start the session. Thank you. Ma'am, on to you. Ma'am, I request you to please start the session. Extremely sorry, ma'am. Just a second.
Hi, am I audible?
Yes, you're audible, ma'am.
Hi, good morning, everyone. Good afternoon, everyone. My name is Advocate Namrata Chandorkar, and today we are going to be learning how to draft something known as a plaint, a written statement, and a replication, all of which collectively are known as pleadings under the Code of Civil Procedure. I don't think I need to introduce myself because Palak did a fantastic job at telling you guys where I come from, and I think we are already well within time, so we'll quickly start the session. So for this session, I have not prepared a PPT that showcases to you the various provisions of the CPC because I think we can all carry the BEAR Act or open it on our browser. But what exercise we are going to undertake today is we are going to see an actual plaint in a civil suit that has been filed before the Honorable Saket Court in New Delhi. We are going to see how we presented the plaint before the court. Then we're going to see how the defendants have given their reply in what is known as a written statement. And to that written statement, the response that the plaintiff gives is known as a replication. And we're going to see that as well. So by seeing real life pleadings, what will happen today is that we will input some practical context to what is otherwise taught to us in law school in the classroom, that is the provisions of Order 7 and 8 of the CPC specifically. So I will just share the screen. How do I do this? Wait. Final plaint copy. Yes. Can everyone see this? Can someone just confirm if they can see the screen I'm sharing?
Yes, ma'am, it's visible.
Okay. Yes, great. So now, what is a plaint? If we were to see section 26 of the CPC, it says that every suit shall be instituted by the presentation of a plaint or in such manner as may be prescribed. So plaint is nothing but a document through which you institute a civil suit before a civil court. The specific provision that governs how a plaint is to be prepared, presented, and how it is admitted in a court of law is governed by Order 7 of the Code of Civil Procedure. Order 7, if we were to have, it's a very comprehensive provision of law. It says, Rule 1 says, particulars to be contained in a plaint. Now let us see whether the draft that we have in front of us, whether it is compliant with the law laid under Order 7. The plaint shall contain the following particulars. Let's see if what we have filed before Saket Court is liable. I think this is Dwarka Court. I'm so sorry. This is before Dwarka Court. It's called Manju Singhal versus Ansal Housing. So let's see whether the plaint that we have filed was compliant in law, whether it is liable to be admitted, or whether it's going to be dismissed on the first day of hearing itself. Order 7, Rule 1A says, the plaint shall contain the following particulars: the name of the court in which the suit is brought. So on the top over here, you can see we have written, in the court of the learned district judge, Southwest, Dwarka District Court, Dwarka, New Delhi. Next, it says the name, description, and place of the residence of the plaintiff. There is something known as a memo of parties over here, guys, you will see. A memorandum of parties basically contains the details of the parties. What details it contains, we will see that when we scroll below. Thereafter, the name, description, place of the resident of the defendant. That is fine. Let us first see what this paper over here is. This is known as the index. In the index, number 1, we will have something known as the court fees. In a civil suit, there is something known as the Court Fees Act, as per which, based on the valuation of your suit, you are supposed to pay some money to the court as court fees. Now, why is this done? This is not sort of a fee you are paying to the court for the court to listen to you. ऐसा नहीं है कि 10 रुपए का आपने note दिया shopkeeper को and then he gives you a Parle-G biscuit, so the 10 rupee is a consideration for that biscuit. Court fees basically, it's the duty. You know what tax, levy, and duty is. So it is a duty that a person who wishes to go to the court has to pay to the government as a consideration for the government to entertain a grievance that the particular litigant is raising. Court Fees Act governs all the civil suits that are filed before the civil courts. When you file something like a writ petition or a special leave petition before the Honorable Supreme Court or a consumer complaint before the NCDRC, even therein you have to pay the court fees, but that is not governed by the Court Fees Act. That is governed by the specific rules of that particular court. Next is something known as a memo of parties, which satisfies subclause A, subclause B, C of the Order 7, Rule 1. Now comes, what is the suit about? This is the title of the suit here, guys. Suit for specific performance of allotment letter dated so-and-so along with supporting affidavit. Next is something known as a list of documents. Of course, with the plaint, the law says under Order 7 that all the documents that the plaintiff is relying on, they have to be filed with the plaint itself. So now we have filed a list of documents. And what is a wakalatnama? Can someone tell me in this lot what a wakalatnama is? If you have studied that in law school, anyone can answer. No one knows what a wakalatnama is? Okay, so wakalatnama, if you guys will have Order 3 of the CPC, a wakalatnama is like an authority letter that a litigant signs giving power to an advocate to appear on their behalf. The advocate will represent the party. Perfect, Riya. That is absolutely correct. So today, let's see this person, Manju Singhal. She's a lady. She's a 70-year-old lady. She wants to file a suit before a Dwarka court. Now, she has, in the wakalatnama, given me the power to appear on her behalf. Let us see the wakalatnama if it is part of the document. We will just see. We will scroll down. Yes. This is what the wakalatnama looks like. It again says the name of the court. It says everything. Then it says wakalatnama. It says, know all to whom the present shall come that I, Manju Singhal, appoint. Now she has appointed all these lawyers of my firm, Magnus Legal Services, blah, blah. And over here is her signature. You guys can see, and this is my signature. So this document is known as a wakalatnama. The client will send us the document on which she has signed here. Then when we receive this document, all the advocates sign here who want to represent her, whom she has authorized to represent them. And this particular document is then filed along with the plaint or the civil suit before the court. Let us now go to... And then thereafter, of course, the plaintiff has to sign the plaint, and it is through her advocate. So her advocates have also signed the plaint. So this is the first page of a plaint, guys. It's known as an index. Any pleading, any petition, application that is filed in a court of law has to be preceded by an index. But there are many lawyers जो index के बिना भी filing करते हैं, but that practice is not very, it's frowned upon in a court. आप जब अपनी practice में आएंगे and you are given the task of creating a draft, ensure that आप उससे पहले एक index लगा दे हमेशा. Let us move on now. As per the index, जो चीजें chronological order में आनी चाहिए वो आएंगी. First is the court fees, जो हमने e-court fees pay की है of 11,128 rupees. So court fees calculator होता है एक as per the court fees act. हर civil suit की valuation होती है. Based on that valuation कि कितने का suit है, उस पे कितने percentage की court fees देनी है, that much you have to tender in the court of law. Now, over here is what we had seen in the index and known as a memo of parties. If we were to go back to Order 7, it says that the name, description, and place of the residence of the plaintiff and so as of the defendant, so far as they can be ascertained. So let us see if we have done that. Okay, memo of party, Manju Singhal is plaintiff number 1. उसका एड्रेस यहाँ पे दिया है. हाउ टू आइडेंटिफाई हर, शी इज द वाइफ ऑफ लेट मिस्टर चित्रंजन कुमार सिंघल. अरविंद सिंघल इज प्लेंटिफ नंबर 2. He is the son of so and so, so we can identify him by this relation, and his place of address is given over here. Versus, who is the defendant? MS Ansal Housing Limited. Now, since it is a corporate entity, it doesn't have any natural existence. It cannot be dragged to a court of law. It has to be represented through its managing director. Again, registered office हमें उनको देना पड़ेगा क्योंकि कल को जब ये plaint admit होगी and the summons has to be served. The defendant being a corporate entity, someone has to be served on behalf of the company. So we have given the registered address of the office of the company. Again, the signature part remains the same. After this particular session, if anyone wants some sample draft or you want to understand better how to do this with other examples, of course we can connect and I will let you have some other examples as well. Now coming to the suit for specific performance of letter dated so and so. हर pleading में, guys, every page that starts let's say a new topic, हमने memo of party में भी देखा कि यहाँ पे भी court name, civil suit number, and in the matter of this entire thing is known as the cause title. I'm not able to highlight it properly, I don't know why, but in the matter of से लेके defendant तक ये entire thing को कहते हैं cause title of the suit. This is the case number and this is the court name. So ये जो पूरा है ये always every page के top पे जाएगा ही. I can't directly start memo of parties because ये memo of parties किस case के under जा रहा है. It is very important to tell the court that. Now let's move on to page number 3. Now this is a suit for specific performance of an allotment letter. Why do we always write most respectfully show it? I mean, it is a colonial practice that we have inherited from when the Brits had taken over India, because most of our legal system comes from or is modeled after the UK law. And perhaps back then pleadings in the UK were written like this, and for some reason we have also inherited. Showeth is not a English language word, perhaps Shakespearean, I guess, but no one in today's world says showeth. Nonetheless, we write like this. We say most respectfully show it, means I am showing to the court most respectfully that. Every paragraph after that will start with the word that. And sometimes people do not know this, that why every pleading is starting with the word that. It is because in continuation of this, it says most respectfully show it that. I am showing you that. That is why every paragraph in almost all pleadings in our country will start with, every para starts with the word that. Any doubts, guys, at this point? It is better अगर हम साथ ही पूछते जाए so that later, you don't have to relegate back pages. Any doubt anyone has? Any question? Okay, none at the moment. So we'll continue. Now, first paragraph of the plaint is usually the description of the civil suit. आप मांग क्या रहे हो कोर्ट से? आप कोर्ट के सामने आए क्यों हो? So I, the plaintiff, says so that present civil suit has been preferred by the plaintiff seeking specific performance of allotment data so and so issued by the defendant to the plaintiff. So this showcases that there is a contractual relationship between the parties which gives cause to the plaintiff to bring the defendant to court. अगर मान लो ये अलॉटमेंट लेटर प्लेंटिफ और किसी और के साथ एग्जीक्यूट हुआ होता, देन दिस स्टेटमेंट डजंट मेक क्लियर कि डिफेंडेंट को आपने कोर्ट क्यों बुलाया. But in this statement, it is very clear that the allotment letter was between defendant, plaintiff, and defendant, and that is why perhaps this civil suit has been filed. Let us move ahead to get more clarity. Specifically, the execution of the conveyance deed to transfer complete and clear title in favor of the plaintiff. So, मुद्दा क्या है, इससे क्या पता चलता है? इससे पता चलता है that in the year 1996, the defendant, that is Ansal Housing, उन्होंने एक allotment letter issue किया plaintiff को कि हम आपको घर बना के दे देंगे. Perhaps उन्होंने घर बना के तो दे दिया, possession was handed over, but उन्होंने कभी sale deed execute नहीं की. So plaintiff might be living in the house, but plaintiff का घर पे title है ही नहीं, क्योंकि कोई conveyance deed as per Transfer of Property Act हुई नहीं है, क्योंकि defendant ने करवाई नहीं. जब allotment letter में ये लिखा होगा कोई clause में that the defendant says that I will convey the title to you, and if he has failed to do so, then a suit for specific performance of that particular clause has been sought. So the first paragraph of every plaint has to be the description of the civil suit. Let us move on. Brief facts of the case. Now, obviously, the court is not going to imagine what happened, what transpired between the parties. So, in very succinct paragraphs, बिल्कुल फलाना ढिमकाना कुछ नहीं लिखना है. In very crisp manner, you have to lay down the facts of the case. You will see that in paragraphs 2, 3, 4, 5, henceforth we are continuing to tell कि भाई ऐसा ऐसा कहानी हुआ. Now everywhere, because order 7 says that all documents have to be produced, we will specifically see that return plaints also blah blah, production of documents. Yes, please have rule 14 of order 7. It says production of document on which plaintiff sues or relies. Where a plaintiff sues upon a document or relies upon a document in his possession or power in support of his claim, he shall enter such documents in a list and shall produce it before the court. So rule 14 बहुत clear है. Rule 14 ने बोल दिया plaintiff अपने सारे document जिन पे वो rely करता है और जो उसकी possession में है, he has to bring before the court in a list. अब list तो हम नीचे देखेंगे, it is there in this civil suit. ऊपर हमने list of documents index में देख लिया था. Now, this is the language used, guys, when you want to annex. Annex is to attach. Now, अगर मैं ये वाले point पे paragraph 3 में जो भी point लिख रही हूँ, इसमें मैंने लिखा है कि defendant ने allotment letter issue किया. अब मैंने नीचे क्या लगा दिया? True copy of allotment letter dated so and so, because ये document मेरी possession में है and I'm relying on this document. मैं इसी का specific performance मांग रही हूँ. So law says you have to produce it with the plaint. True copy. अब allotment letter के original तो मैं लगाऊंगी नहीं, because all original documents, मतलब what if I give them to the court and the court loses them? So the law says that you have to produce true copies of the document. A true copy is a exact copy without any manipulation of the original document. True copy of the document dated so and so has been attached and annexed herewith as annexure P1. कुछ लोग enclosed herewith भी लिखते हैं. The language can differ, but हमने यहाँ पे ये annex कर दिया है. फिर पूरे facts बताए गए, everything was written down. This is specifically crucial because order 7 says that मेरा जो exact मुद्दा है, that I have to lay down in the plaint, the exact specifics of the relief sought and why. So I am saying over here that as per clause 19 of the allotment letter, defendant was obligated to execute the conveyance deed in favor of the plaintiff. मैंने exact कौन सा clause है वो भी लिख दिया यहाँ पे. Thus, it can be seen that as per the allotment letter, defendant had to first raise a call so and so and so. However, defendant has miserably failed to do so. So this is my cause of action, that there was an agreement. Agreement का clause ये कहता है, but defendant has not done this. So very specifically, my relief and my grievance I have stated in the plaint. Now, over here, cause of action and limitation. This is very important. Because if you will see rule 1 again, particulars to be contained in a plaint, please see subclause F. It says facts showing that the court has jurisdiction. So now we have to showcase over here why this court has jurisdiction, why the facts constituting the cause of action and when it arose. So cause of action and limitation and jurisdiction. All of these paragraphs have to go separately. क्या लिखा हमने cause of action में? It is humbly submitted, present suit is filed within the limitation period. Is very important. Limitation Act कहता है सिविल सूट 3 years में फाइल होगा. अब अगर मैं 5 years के बाद फाइल करूं तो मेरा तो लिमिटेशन बाहर हो जाएगा. तो मुझे कोर्ट को स्पेसिफिकली बताना है दैट सर लिसन, मैंने जो टाइम पीरियड प्रिस्क्राइब्ड है अंडर द लॉ उसी के अंडर मैंने सिविल सूट प्रेफर किया है. हाउ डू आई मेक आउट लिमिटेशन? मतलब 3 years फ्रॉम विच पॉइंट इन टाइम? ऐसा तो नहीं कि 3 years फ्रॉम 100 BC आफ्टर क्राइस्ट, कुछ भी आप ऐसा डेट नहीं ले सकते. सो यू हैव टू इन द प्लेंट स्पेसिफिकली टेल देम दैट फ्रॉम द डेट, फर्स्ट डेट when the cause of action arose. यहाँ पे हम लोग ये डेट ले रहे हैं 21/04/2021, wherein so and so क्या हुआ उस दिन को पूरा हमने कोर्ट को बता दिया. हम यहाँ लिखते हैं present suit has been filed within 3 years from that date, hence is within the prescribed limitation period. So we have जो subclause E है, facts constituting the cause of action and when it arose, this we have satisfied. Moving on to the next, whether the court has jurisdiction. There are two types of jurisdiction that usually a court should have. One is a territorial jurisdiction, one is a pecuniary jurisdiction. Even if the court has one and the court doesn't have other, the civil suit is not liable to be entertained, it will be dismissed. अगर मान लो territorial jurisdiction है, कैसे बनता है territorial jurisdiction as per CPC? Anyone can answer that? Which section governs it? Come on, guys.
15 to 20.
Sorry?
Sections 15 to 20 of CPC.
Correct. Absolutely right. It is 15, 16, 17. 15 governs in which court the suit will go. So obviously lowest grade के court में जाएगा. ऐसा नहीं है कि ये वाला suit अगर मैं district judge के सामने डाल सकती हूँ, मैं high court चली जाऊंगी. I am barred to do so. I have to institute it in the lowest grade competent court that is possible. Suits to be instituted where subject matter situate. 16 will say that where the cause of action arose or where the immovable property is situated. 17, 18 is fine. 20, other suits to be instituted where defendants reside or cause of action has arisen. Defendant का जहां पर भी registered address है, और if the defendant is an individual, वो ordinary place of residence and business में कहाँ रहता है, उस area के lowest grade court में a civil suit will be filed. What have we written here? Honorable Court has appropriate territorial jurisdiction as the suit property is located within the territorial jurisdiction of this Honorable Court, that is in Vikaspuri, New Delhi. Vikaspuri में जो cause of action arise हुआ है, which is the situation of the suit property, उसकी jurisdiction द्वारका court में lie करती है, hence I have gone to Dwarka court. Let's see pecuniary jurisdiction. That the valuation of the present suit for the purposes of the pecuniary jurisdiction shall be the amount of there is something known as Suits Valuation Act, as per which एक specific performance के suit की valuation जो ओरिजिनल कॉन्ट्रैक्ट के अंडर जो कंसिडरेशन होता है उस पे होती है. अब आप देखेंगे कि ये इतनी कम की प्रॉपर्टी क्यों है, बट यू विल ऑल्सो रियलाइज दैट 1990s का अलॉटमेंट लेटर है. उस जमाने में जो प्रॉपर्टी अलॉट की थी अंसल ने, वो 8 lakhs में की थी. आई मीन टुडे इट्स 2-3-4 crores वर्थ ऑफ प्रॉपर्टी. उस जमाने में अगर वो 8 lakhs में की थी, तो आज भी इफ आई एम फाइलिंग अ सूट, मेरी जो पेक्यूनरी ज्यूरिसडिक्शन होगी वो इस पे बेस्ड होगी. अगर मान लो ये 2 crore से ऊपर होता है ये सम, देन दिस सूट टेरिटोरियल ज्यूरिसडिक्शन तो होता है द्वारका कोर्ट के पास, बट उसके पास पेक्यूनरी ज्यूरिसडिक्शन नहीं होता, बिकॉज suits that are valued above 2 crores go to the Delhi High Court. Delhi High Court has original site civil jurisdiction as well. Any doubts until now, guys? ऐसा कुछ जो समझ नहीं आया हो या जो वापस देखना है आपको इस प्लेंट में? Anyone? Okay, then we'll move ahead. Valuation of suit and court fees की हमने कैसे कैलकुलेट किए वो भी हमने कोर्ट को बता दिया. Now let us come to something that is very crucial. कि प्रेयर क्या है आपकी? बिकॉज आपने पूरा कथा लिख दिया, कथा के बाद प्रेयर ही नहीं लिखी, देन द कोर्ट इज गोइंग टू आस्क यू कि मैं स्टोरी का करूं क्या, व्हाट एम आई सपोज्ड टू डू, व्हाट डू यू वांट, व्हाई आर यू टेलिंग मी ऑल ऑफ दिस. सो वी हैव टू टेल देम कि हमारा प्रेयर क्या है. Because order 7, rule 7 says, if you will have, it says relief to be specifically stated. Every plaint shall state specifically the relief which the plaintiff claims, either simply or an alternative. ठीक है, that is fine. So every plaint has to specifically state the relief. तो हमने यहाँ पे prayer clause बना दिया. In view of the submissions made here and above, it is humbly submitted that this honorable court may be pleased to first decree the present suit. Obviously, अगर वो decree नहीं करेगी, dismiss कर देगी, तो then you are not getting anything. Pass a decree of specific performance of allotment letter in favor of plaintiffs and against defendant. Direct the defendant to execute conveyance deed. Award cost of the present suit in favor of plaintiff. These are all ancillary prayers. Your main prayer is this, कि आपने एक सूट फॉर स्पेसिफिक परफॉर्मेंस फाइल किया है बिकॉज यू वांट दैट एक डिक्री पास हो जिसमें ये डायरेक्शन दी जाए डिफेंडेंट को कि आप कन्वेयंस डीड एग्जीक्यूट करके उस प्रॉपर्टी जो आपने अलॉट की थी 91 में उसका टाइटल मुझे आप दे दो. Now verification. Can someone tell me why this verification is over here, under which part of the CPC a verification of a plaint is required? Anyone can answer that. No one? Okay, for that we have to go back to order 6, pleadings generally. अगर उसमें आप लोग rule number 14 देखेंगे, so it says pleading to be signed. Every pleading shall be signed by the party and his pleader. It doesn't say and or. इसका मतलब अभी तक ऊपर जहां मैं अपनी ये signature मार रही हूँ, मेरी signature नहीं चलेगी. This plaint has to be signed by the plaintiff. That is why you will see यहाँ पे plaintiff का sign है. प्लेंटिफ नंबर 1 का भी साइन है यहाँ पे मंजू सिंघाल एंड प्लेंटिफ नंबर 2 का भी साइन है अरविंद सिंघाल. मान लो फॉर सम रीजन इफ ये वेरिफिकेशन नहीं होती, डे 1 को ही ये प्लेंट डिसमिस हो जाती, अगर कोर्ट को ये दिख जाता कि इट्स एन अनवेरिफाइड प्लेंट, वो मुझे वापस कर देता डॉक्यूमेंट, बोलता मैम आप इसे वेरीफाई करवा के लाइए, रीफाइल इट, तभी मैं ये केस ले पाऊंगा. सो दिस वेरिफिकेशन एज पर ऑर्डर 6 रूल 14 इज वेरी इंपॉर्टेंट. So this is how a plaint is created, guys. अब इसके नीचे भी obviously there is going to be a list of documents हमने देखा था. This is known as a supporting affidavit. हमने index में लिखा था civil suit along with supporting affidavits. Affidavit क्यों लगाना जरूरी है? इसमें basically लिखा है कि जो accompanying suit के contents है वो मैंने समझ लिए हैं और वो true and correct है. That is all an affidavit says. Every pleading in the court of law is accompanied by an affidavit. Why? बिकॉज बात बड़ी सिंपल है. अगर जैसे आई एम नम्रता चांदोरकर, मैंने ये प्लेंट साइन कर दी, बट मेरे बिहाफ पे तो केस नहीं जा रहा ना. आई मीन आई एम नॉट सेइंग दैट सो एंड सो हैज हैपेंड विद मी. आई हैव फाइल्ड दिस ऑन बिहाफ ऑफ समवन. अब ये समवन को भी तो कोर्ट के सामने आके बोलना पड़ेगा ना कि ये सब ट्रू है और ये मैंने ही, मतलब आई एम अवेयर दैट दिस हैज हैपेंड, दिस इज ट्रू एंड करेक्ट एज पर माय नॉलेज. दैट इज व्हाई एन एफिडेविट goes. If there is no sign of the plaintiff or the petitioner and सिर्फ वकील फाइल करने लगे, then veracity of statements before the court of law will be easily challengeable. कोई भी कह सकता है कि ये तो वकील कह रहा है, ये तो litigant कह ही नहीं रहा. Which is why a litigant always has to submit an affidavit before the court of law. Also, when you say they are true and correct, as per my knowledge, कल को मान लो प्लेंट में ऐसा कुछ आपने झूठ बोला हो, if that is proven by the other side, then you are also guilty of perjury. आप पे contempt of court का केस होगा, because in your affidavit you have written that आपने जो बोला है वो सब true and correct है. If tomorrow the court finds that okay, no, you have not come with clean hands, आपने कोई झूठ बोला है प्लेंट में आपके केस में, then आपके ऊपर perjury का केस भी under CRPC or the new act वो हो सकता है. एफिडेविट इज फाइन, नोटरी होती है, ओथ भी हो सकता है. ओथ एंड नोटरी का डिफरेंस गाइस इज अ कंप्लीटली डिफरेंट टॉपिक, बट पब्लिक नोटरी इज एक्सेप्टेबल. Now list of documents, because we had seen order 7 says that every document which the plaintiff relies on has to be produced. Order 7 rule 14 says so. These are all the documents that I am relying upon. Annexure P1, 2, 3, 4, 5, 6, 7. उसका जो description है document का वो और उसकी page numbering यहाँ पे है. And thereafter, all the documents will obviously be part of the plaint. ये पूरा ही फिर वो है. In the end, we have something known as a wakalatnama, which we have seen. So this is a plaint. Any doubts, guys? Because once we move on to the written statement, बहुत मुश्किल हो जाएगा to go back. Any doubts anyone has? कि plaint कैसे बनती है? Any doubts? Law क्या है? Come on, let's make it an interactive session. What happened? No questions? Am I
It's
that
clear,
bad
ma'am.
of a teacher? Yes, who's there?
It's clear, ma'am.
It's clear? Okay.
Ma'am,
Chalo.
could you please share that PDF once in a group, ma'am, so that we can refer it further?
How do I do that? Palak, can you help me with that? मैं आपको भेज दूँ ये?
Sure, ma'am, I have no issues. You can send the PDF to me and I'll convey it in the group.
Okay, so I'll just do that once this session is over.
Thank you, ma'am.
Anyone else has any doubts?
Ma'am,
Yes.
excuse me. Just I had a doubt.
Yes.
What is the required documents for the which section is providing a list of documents? Basically on the base of suit, it will determine the list of documents. How can you say that these or documents are mainly applicable for this? How can we assure that these are the main?
राइट वेरी गुड सो क्या होता है कई बार जब क्लाइंट आपके पास आता है मान लो क्लाइंट कम्स टू एंड सेज मेरा ये प्रॉब्लम है वकील साहब ही विल कम विद अ वेरी बिग फाइल ही विल ब्रिंग एवरीथिंग टू यू वो A to Z सारे डॉक्यूमेंट्स ले आएगा बट नॉट एवरी डॉक्यूमेंट इज रेलेवेंट फॉर द शोकेसिंग ऑफ अ कोर्ट अब इस केस में कैसे इफ यू आर सीकिंग अ सूट फॉर स्पेसिफिक परफॉर्मेंस इट इज बट ऑब्वियस की जो कॉन्ट्रैक्ट है जिसका स्पेसिफिक परफॉर्मेंस आप मांग रहे हो वो तो आप लगाओगे ही अगर आप एडमिट करते हो कि मेरे को पोजेशन मिल चुका है फ्लैट का बस खाली सेल डीड नहीं हुई तो आप हैंडओवर लेटर लगाओगे हैंडओवर लेटर इज अ लेटर विद विच पोजेशन इज हैंडेड ओवर so you will if you're telling the court I have received possession you have to prove it by showing a document so आपने ये लगा दिया in the plaint I have also said कि मैं पिछले 20-25 साल से इस प्रॉपर्टी का मेंटेनेंस भर रही हूँ if I am not the owner of the property legally मैं इसका मेंटेनेंस क्यों भर रही हूँ बट nonetheless डिफेंडेंट ने कोई चॉइस ही नहीं छोड़ी उसने मेरे को पोजेशन दे दिया and he said that आप मेंटेनेंस भरो if I am pleading all of this जो मैं आपको बता रही हूँ I have to showcase so मैंने रिसीट्स लगा दी आई एम ऑल्सो सेइंग दैट भाई मेरा तो कोई टाइटल नहीं है प्रॉपर्टी में तो भी प्रॉपर्टी टैक्स मैं दे रही हूँ तो इट इज इन द इंटरेस्ट ऑफ जस्टिस कि आप टाइटल भी मुझे दिलवाओ अगेन आई हैव टू प्रूव इट Now my Manju Sinha's husband, the original allotee, he passed away. उसका डेथ सर्टिफिकेट लगाना बहुत जरूरी है बिकॉज ही इज द ओरिजिनल अलॉटी आज कोर्ट को मंजू सिंघाल क्यों आ रही है और चित्रंजन कुमार सिंघाल क्यों नहीं आ रहा है कोर्ट के सामने ये बताना बहुत जरूरी है सो वी हैव अटैच्ड हिज डेथ सर्टिफिकेट Before filing a suit, we sent the defendant a legal notice to see कि out of court settlement कुछ हो रहा है कि नहीं वो मैंने लगा दिया उसकी स्पीड पोस्ट रिसीट विद ट्रैकिंग रिपोर्ट लगा दी मेरे जितने अवर्मेंट्स थे सारी प्लेंट में दे ऑल स्टैंड प्रूव्ड बाय दीज डॉक्यूमेंट्स आई हैव नॉट सेड एनीथिंग इन द प्लेंट फॉर विच आई डोंट हैव अ डॉक्यूमेंट जो मैंने यहाँ एनेक्स नहीं किया हो सो दिस इज हाउ यू हैव टू सी आप जो फैक्ट्स प्लीड करते हो एंड आपके पास जो बंडल ऑफ डॉक्यूमेंट्स है यू हैव टू कल आउट दोज डॉक्यूमेंट्स which corroborate the facts you are placing before the court. All documents have to be produced. अगर plaint के साथ मान लो नहीं produce किया है, the law bars you to bring them with your evidence affidavit. आपको एक स्पेसिफिक एप्लीकेशन लगानी पड़ेगी कोर्ट में टू ब्रिंग एडिशनल डॉक्यूमेंट्स ऑन रिकॉर्ड एंड वो हैजल होता है वो कोर्ट कभी अलाउ नहीं करती इसीलिए इट इज वेरी क्रूशियल कि जब प्लेंट ड्राफ्ट कर रहे हो तभी सारे डॉक्यूमेंट्स रिकॉर्ड पे आ जाने चाहिए अगर कोई छूटा सो इट बिकम्स एडवर्सरियल टू द केस ऑफ द लिटिगेंट डज दैट आंसर योर क्वेश्चन सर
Yes, ma'am. Thank you so much. And ma'am, can I ask another question?
yes
Yes, there is a writ has been filed in Telangana High Court. It was filed in 2023.
okay
The respondent is now responding by on the notice. He is responding 2025. Like there is a time between these 2 years. Like will it be executed or not? What is the time limit in what in writs, mainly in writs? One of my friends said that there is no time limit for this. Can you explain this?
Correct. There is for a writ petition there is no limitation. Limitation Act or any other law does not lay down कि writ petition कितने time में file होनी चाहिए. But yes, आपको आपकी रिट पिटिशन में ये लिखना बहुत जरूरी है कि जो भी डिले हुआ मान लो आज कोई कॉज ऑफ एक्शन आता है और मैं 10 साल बाद फाइल करती हूँ मुझे लिखना होगा पिटिशन में कि मैं 10 साल तक क्या कर रही थी कोर्ट वो देखेगी कोर्ट इज गोइंग टू रीड कोर्ट इज गोइंग टू इंक्वायर फ्रॉम द काउंसिल की व्हाट वर यू डूइंग फॉर 10 years if a suitable answer justifying that 10 years period is given, court will still entertain your writ petition. But मान लो court को ये भनक लग गई कि भाई आप तो अपने rights पे सो ही रहे थे. You could have filed a writ petition way back in time, but आप सो रहे थे अपने rights पे. Hence, I will not grant you this relief today. So it is very subjective, case to case basis पे होता है. But general law says that without any inordinate delay, you must approach the court of law. Does that clear your doubt?
Yes, thank you so much.
Inordinate delay facts पे depend करता है. कई बार continuous cause of action भी होती है. जैसे for instance मान लो कि मैं जिस घर में रहती हूँ इसके टॉप फ्लोर वाले ओनर ने कुछ इलीगल कंस्ट्रक्शन कर लिया. उसने अपनी टेरेस बाहर निकाल ली. उसकी टेरेस बाहर निकालने की वजह से जो मेरी सनलाइट है जो मेरे घर में आती है, मेरा ईजमेंट्री राइट अफेक्ट हो रहा है. अब इसके लिए ऑब्वियसली मैं एमसीडी को एक कंप्लेंट लिखूंगी कि सो एंड सो हैज हैपेंड. एमसीडी अगर कोई एक्शन नहीं लेती, देन आई हैव the right to file a writ petition against MCD because MCD is a public authority. Now this writ petition I can't file after 15 years. 15 साल तक उसने टेरेस बांध रखा है, मैं कोर्ट नहीं गई. तो व्हाट इज द टाइम पीरियड? इसमें अगर मान लो एमसीडी को मैंने चिट्ठी लिखी और मैं 6 महीना रुकी, 6 महीने बाद एमसीडी ने कोई कुछ नहीं कार्रवाई की. आई राइट अनदर लेटर टू एमसीडी दैट प्लीज उनको बोलो ये डेमोलिश करिए, हटाए स्ट्रक्चर. अगेन 6 months pass by. 1 year later, I am done. I'm fed up. I say I'm going to the court. मैं writ petition file कर रही हूँ. Now the court is going to ask me, madam, आप 1 year तक क्या कर रहे थे? I have to explain to the court that I wrote one letter to the MCD. I awaited action for 6 months. I then wrote a gentle reminder. And when after 6 months of inaction again, when I had no efficacious remedy left, I have come before this honorable court. There's a very good chance that High Court मेरा case accept भी कर ले. That is how it works. Any other doubt, guys? Okay, so we will now move on to something known as a written statement. Can someone tell me what is a written statement?
Ma'am?
Yes.
I'm stopping you for some moment. I have an
Yes.
announcement to make for all our participants. We are excited to announce an upcoming course on civil litigation practices and procedure in which Namrata ma'am will personally conduct most of the sessions. This comprehensive program will cover essential civil litigation practices, in-depth provision of the Code of Civil Procedure, the Specific Relief Act, and the Law of Limitation. You will receive recorded sessions for flexible learning and practical sample templates to support your practice. Stay tuned for the registration details and join us to strengthen your expertise in civil litigation. Thank you, ma'am. We can proceed further.
Okay, thank you, Palak. I think, guys, why it is important to learn the CPC in a very practical context is because personal experience se bataungi. I'm a first generation lawyer. So I didn't have anyone in the family I could see and learn from that what is litigation. And since school time, since high school, I always wanted to be an advocate because मुझे public speaking में interest था, and I found law to be a very interesting subject in a way that everyday transactions में भी there is always law. आप अपने पर्सनल रिलेशंस ले लो, वो गवर्न बाय लॉ है. आपकी प्रॉपर्टी गवर्न बाय लॉ है. आप जो खाते हो, खरीदते हो, वो कंज्यूमर लॉ से गवर्नड है. आपके एवरीडे एग्जिस्टेंस में जो फंडामेंटल राइट्स आपको मिलते हैं, टू क्लीन वाटर, to food, to entertainment, to privacy. I mean, law is everywhere around, and that fascinated me. But I had no practical exposure. मुझे कॉलेज में प्रोफेसर्स ने सिर्फ ये किताब पढ़ा दी, वर्ड टू वर्ड, रॉट लर्निंग से ही एग्जाम भी पास कर ली. कोई प्रैक्टिकली बता नहीं रहा था कि हाउ डज दिस इम्प्लीमेंट इन कोर्ट. आई हैड नॉट सीन अ प्लेंट और अ प्लीडिंग फॉर द फर्स्ट टाइम until I started my legal traineeship under Mr. Nikhil Singhvi. He's a lawyer in New Delhi. So I think if I could go back in time, मैं एक certificate course या at least some sort of practical training from an advocate, practicing advocate लेना चाहती. That opportunity was not made available to me, but you guys have that opportunity. You must enroll with, I'm not saying this course, you are a consumer, there are various courses in the market. आपको ये opportunity लेनी चाहिए. You must browse through what is there out there. And if, of course, you get enrolled in this course, you will have one-on-one experience with me. And I never consider this as an opportunity of me teaching something to someone. ये मेरी भी learning है. Because ये course conduct करने से पहले मैंने किताब खोली, I read through, I browsed through, मैंने revise किया. So in a way, it is like a combination that you also learn and I also learn. And I think that is what is fantastic about the certificate course that Lisperitus has created. So please do enroll, guys. It would be very exciting. ये पूरा किताब है, यही है. Civil courts are governed by this. I mean, CRPC तो बदल गई, they amended it, but no one could amend this because this code is so comprehensively and beautifully written. It covers every aspect that a civil court can ever face in any sort of civil suit. बहुत टाइप के होते हैं. Specific performance तो बहुत छोटी चीज हो गई. जब आप करोड़ों की रिकवरी करते हो, डिक्री आती है, कैसे एग्जीक्यूट होती है. I mean, this code governs everything and it's beautifully written. तो अगर ड्यूरिंग योर लॉ स्कूल ओनली यू गेट द एक्सपोजर जहां आप ये पढ़ पाओ कि ये प्रैक्टिकली कैसे दिखता है, आई थिंक दैट विल गो अ लॉन्ग वे इन योर करियर. Yes, sorry for that digression. We will move on to the written statement. अब अंसल हाउसिंग ने इसका क्या written statement produce किया था, एक बार अपन वो देखते हैं. This is the written statement. I don't know if the document is visible. दिख रहा है सबको?
Yes, ma'am, it's visible.
Okay, so now let's see what Ansal Housing says. They say written statement on behalf of defendant along with supporting affidavit. They have filed an affidavit of admission denial. वो क्या है? It's a very different issue. वो plaint के अपन इसमें आज cover नहीं करेंगे. Application for condonation of delay. Why they had to provide one, we'll see. Proof of service that they have served a copy on me. Yes, can someone tell me written statement is governed under what order, section, provision of the CPC?
Order 8, madam.
Order 8. Perfect. Now, Order 8, Rule 1 says defendant shall within 30 days from the date of service of summons. So, if there is an application for condonation of delay, one is safe to presume that इन्होंने 30 days के beyond अपना written statement file किया है. जो delay है उसके application for condonation उन्होंने file की है. Summons to him, present a written statement of his defense, provided that where the defendant fails to file a written statement within the period of 30 days, he shall be allowed to file the same on such other date for reasons to be recorded in writing. मतलब if the court is allowing कि आपने 30 days के बाद फाइल किया है but मैं allow करता हूँ, तो court को reason देनी पड़ेगी कि मैं क्यों allow कर रहा हूँ. And those reasons are of course imported from the application for condonation of delay. वो court मान रही है जो explanation defendant दे रहा है. Yes. Now let us move on to the written statement. Obviously, at the very outset, defendant denies all averments, contentions, and so and so. Why is denial necessary to be specific, guys? Why is this paragraph not enough? If he is denying everything, why didn't this written statement just end over here? Can anyone answer? The answer lies in Order 8 only. अगर Order 8 के rules देखेंगे तो समझ जाओगे what the question is. Anyone? Okay, no issue. We'll see Rule 3. It says denial to be specific. It shall not be sufficient for the defendant in his written statement to deny generally the grounds alleged by the plaintiff, but the defendant must deal specifically with each allegation of fact of which he does not admit the truth except damages. So now you see that this one paragraph by law is not sufficient. You cannot generally say, हाँ ये सब तो मैंने किया नहीं, bye. That's not acceptable. You have to specifically deal with every allegation and fact raised in the plaint. But before that, usually defendants write something known as preliminary objections in their written statement. Can someone just guess कि ये preliminary objection क्या होता है? Why didn't they सीधा go to para 1 का reply ये है, para 2 का reply ये है? What is preliminary objection? Objection तो आप उठा ही रहे हो, आप written statement file कर रहे हो, तो what is preliminary about it? Can someone answer? Come on, guys, let's make it slightly more interactive. No one? Okay. It says so because there is something known as the maintainability of a plaint. If it is limited, time barred है कि limitation में नहीं file किया गया, pecuniary jurisdiction नहीं है, territorial jurisdiction court के पास नहीं है, the civil suit is barred by some specific provision of law. N number of objections can be raised that plaintiff has no locus to file this complaint. Wrong defendant has been impleaded. Defendant can come and say that these allegations ought not to be raised against me. मैं तो कोई अलग ही defendant या company हूँ. So all of these are preliminary. मतलब these should be adjudicated before the matter is looked into upon its merits. Now, what do they say in preliminary objections? They say, and 3 is very important, it says this learned court lacks the jurisdiction to adjudicate the dispute as the present suit is a commercial dispute within Commercial Courts Act and cannot be. बात तो इसकी सही है. The property in question जिसकी आप conveyance मांग रहे हो वो तो एक commercial property as per allotment letter of 91, तो it falls as a commercial dispute under the Courts Act. तो ये तो commercial court के सामने जाना चाहिए था, मैंने civil court के सामने file करके गलती कर दी. It is a preliminary objection that it is not maintainable. Now what they say, the present suit is barred by limitation. लो जी, ये कह रहा है कि आपने relief जो है वो 20 years of possession and acceptance of terms के बाद मांगा है, तो आपका तो present suit barred by limitation है. The present suit is dismissed for non-joinder of necessary party. वो कह रहा है defendant कि एक ऐसी proper and necessary party है जिसको आपने implead नहीं किया, that is Delhi Development Authority, because ये ही आपकी जो sale deed है इसे execute करवाएंगे, ये leasehold land होगी, इसलिए ऐसा लिखा है इन्होंने. Now the present suit is liable to be dismissed for non-joinder of all legal heirs. मिस्टर चित्रंजन कुमार सिंघल की एक डॉटर भी है दीपाली कोहली, जिसको आपने पार्टी नहीं बनाया. अगर चित्रंजन कुमार सिंघल जी मर गए हैं, आप उनके वाइफ एंड सन को लेके आए हो एज प्लेंटिफ, देन व्हाई इज द डॉटर नॉट अ पार्टी? इवन शी हैज अ राइट इन द प्रॉपर्टी ऑफ अ फादर. Present suit is undervalued and inadequate court fees has been paid. The value of the property in question is much higher than what is declared in the plaint. वो कह रहा है कि आपने जो 8 लाख की वैल्यू बताई है वो आज करोड़ों की है, तो आपने तो plaint की वैल्यूएशन ही गलत की है. So these are the preliminary objections. These don't go into the merits of the allegations raised. They are just saying that the present plaint is non-maintainable. Preliminary submissions are written in. So first you say there is a first paragraph that it is denied. Then you saw preliminary objections are written. Now something known as preliminary submissions are written, wherein the defendant tells his version of the facts. आपने plaint में facts of the case जो लिखे थे, defendant अपने facts preliminary submission में बताएगा. And then he has gone on to ramble. He said so and so and so. Plaintiff cannot challenge conditions after 22 years. उसने अपनी story बता दी कि ये हुआ था उस time. Now it is very crucial parawise reply, because we just saw that it says that denial has to be specific. Rule 3. So now if denial has to be specific, there is a parawise reply in every written statement wherein per para of the plaint the defendant will reply. Contents of para 1 of the suit require no comments. They are wrong and denied, and so on. वो पूरे plaint के सब contents को या तो deny करेगा, wrong बोलेगा, admit भी कर सकता है अगर if it has actually happened. Let's see if there is any admission on part of the defendant over here. No, he has not admitted anything. He has denied everything that we had written in our plaint. Great. So all of this he has said. Prayer clause is wrong, denied in view of the fact that humbly submitted that the court may be pleased to dismiss the suit. This is his relief. The relief he is seeking that आप ये suit dismiss कर दो. Same जैसे हमारे इसमें था, a pleading has to be verified. We have seen under Order 6 Rule 14. So the pleading has been verified by the party. Now obviously Ansal Housing will not come, being it is not a natural person. It has no physical existence. So obviously through its authorized representative, the written statement has been verified. इसका भी एक affidavit आएगा जहाँ पे ये अवनीश कुमार, who apparently is the AR, the authorized representative of Ansal, he has said that सब सही है. There is an admission denial. This is something different. We will not go into this today. Now coming to application under Order 8, Rule 1, read with 151 for condonation of delay. If this written statement is not filed within 30 days, every defendant will file this application with their written statement. आप लोग एक बहुत मस्त चीज देखोगे that this particular party has not filed any documents along with their written statement. जबकि Order 8 में लिखा है in Rule 1A, duty of defendant to produce documents upon which relief is claimed or relied upon by him. Whatever he has stated in his written statement, उसके अगर कोई documents थे तो he was liable to bring them, but he has not. अब ये क्यों हो सकता है? It is also possible A, because defendant ने गलती कर दी, उसको अब आगे जाके trial में दिक्कत होगी, या B, उसका जो भी averment है उसको prove करने के लिए कोई document है ही नहीं. That is why he has not annexed anything. मुद्दा जो अलॉटमेंट लेटर वगैरह का है वो तो anyway I have filed with my plaint, so it is on record. There are no documents that he wants to bring on record. Bear it in mind, not tomorrow with his evidence he cannot bring new documents. If with his written statement he has not brought any documents. So this is how a written statement looks, guys. ये तो बहुत easy था, मतलब इसमें there is not much difficulty except that creating a defense in itself is a very tedious task. Written statement बनाना plaint बनाने से बहुत आसान है, but defense create करना, जो story है उसे ढंग से लिखना, that is the challenge in a written statement. Any doubts anyone has? We have covered both compulsory pleadings of plaint and written statement of the same matter. तो आप देखेंगे कैसे एक court में ये चलता है. Any doubts? We'll quickly wrap up in another 5 minutes. एक replication बचा है, but replication is not a compulsory pleading. अगर court आपको permission देती है तो आप written statement के contentions, अगर कुछ नया raise है, जैसे preliminary submission में आके defendant ने कुछ नई कहानी बना दी, now plaintiff wants to give a reply, so वो एक replication file करेगा, which looks like this. Replication on behalf of the plaintiff to the written statement file, and then again para-wise reply to उसमें written statement चला जाएगा. आप पूरा जो आपको बोलना है written statement के खिलाफ बोल सकते हो. So this is how a replication looks. So guys, this is how pleadings are prepared. The definition of pleadings is given in Order 6. Order 6 Rule 1 says pleading shall mean plaint or written statement. तो अगर कल को आप कहीं पर भी pleading word सुनो, under CPC it means either a plaint or a written statement. It does not mean a replication. Can someone tell me replication कौन से इसके अंदर फाइल होता है? Anyone? Denial, departure. I am unable to find it. Verification, amendment of pleadings. Rule 17 of Order 6 is very important. अगर मैंने कोई plaint बनाई है और कल को पता चलता है मैंने उसमें कुछ बहुत ही crucial छोड़ दिया, then I have to file an application under Order 6 Rule 17 for amendment of plaint or written statement. दोनों ही pleadings उसमें जाती है. Wherein I have to show cause to the court that why I failed to write XYZ in the first time when I filed a plaint and why now it should be taken on record. So that is very important. Anyone has any doubts over here? So that's the end of the session from my side. Palak, you can take over.
Can I ask a question?
Yes.
Like you right now you said that on written statement, without documents they are providing like they are making some of the statements. Like
Yes.
the court will entertain or not. Like it is not sustained. Like I felt in my own view. What's your point of view? Like how the court entertain over there?
We'll see the written statement once. Let's see उन्होंने क्या लिखा है जो ऐसा है. Para-wise reply में वो लिख रहे suit is wrong and denied. It is denied that Chitranjan is an application. So उन्होंने basically सब कुछ deny ही किया है और उनका जो major case है that is challenging the maintainability of the suit itself. अगर वो कह रहे हैं Mrs. दीपाली कोहली को आपने पार्टी नहीं बनाया तो वो तो मैंने ही plaint में admit कर दिया है. When you see the death certificate उसमें legal heirs के नाम आ जाते हैं. Everything that he is saying, the company is saying in the written statement, it requires no documents. Of course, I will share these pleadings with you in the group. आप भी एक बार उनमें जाइए. You will have my number. If you feel that in this document he has written something that could be corroborated by a document, you can please then contact me. We will have this exercise later. I think it is very important to be inquisitive and curious in this field. I like the fact that आप question पूछ रहे हैं. इन माय ओपिनियन जो रिटन स्टेटमेंट उन्होंने बनाया है उसमें ऐसी कोई उन्होंने अवर्मेंट ली ही नहीं है जिसको कोरॉबरेट करने के लिए कोई डॉक्यूमेंट उन्हें लाना पड़े या ऐसा कोई डॉक्यूमेंट जो एग्जिस्ट करता हो. दे हैव कंप्लीटली चैलेंज्ड द मेंटेनेबिलिटी ऑफ माय सूट व्हिच इज मोर ऑफ अ लॉ पॉइंट rather than a factual issue. It's the legality which he has to argue basis the provisions and the judgments. So no documents he has presented with his written statement. But of course you are free to review it. I'll be sharing these documents with you. Anyone has any other doubts?
Last question.
Hanji.
Like verification of document, like will it be like there is an unregistered deed will it be verified by will it be executed in the court?
No, so verification is just that verification पे वो sign मारनी है. It is not an affidavit जिसकी public notary या oath commissioner के पास जाके oath करानी पड़े. Verification is just a simple sign on the paper. कोर्ट में नहीं होता वो, फाइलिंग से पहले ही होता है. सो टुडे इन माय ऑफिस इफ मी एंड माय क्लाइंट आर सिटिंग, मैं क्लाइंट को बोलूंगी आप वेरीफाई कर दो इसे, तो वो वही साइन कर देगा, फिर मैं ये जाके कोर्ट में फाइल कर दूंगी. ये कोर्ट के सामने नहीं होता है. It is not like a criminal proceeding wherein a magistrate under section 200 has the power to call a complainant and examine him. Civil courts में everything works on affidavits. In fact, जो evidence जाता है under order 16 if I am not wrong, वो देखना पड़ेगा. If order 16 क्या कह रहे हैं? Is someone saying something?
Order 19, madam.
It's order 19. It is order. No, it is order 16 only. Summoning and attendance of witnesses. So, इसमें procedure for a witness. Henceforth 17, 18, 19 में भी है. Everything goes on an affidavit. When I have to give my evidence, वो जैसे movies में दिखाते हैं ना कि वो वहाँ पे खड़े रह के सवाल पूछे जाते हैं, वैसे नहीं होता. आपको सब एक affidavit पे लिख के दे देना होता है. If a specific cross-examination is required, the party can file an application. But it is not like a sessions court trial जहाँ पे एक party को बुला के court में ही सब कुछ examination and cross हो रहा है उनका. Civil court में ऐसे नहीं होता. Any other doubts? That's it? Okay, Palak, I think we are good to go.
Yes, ma'am. As you said, let's wind up this session. As we conclude this insightful seminar, I extend our heartfelt gratitude on behalf of the organizing committee to our esteemed guest, Advocate Namrata Chandorkar ma'am, for her inspiring keynote presentation and engaging discussions that offered valuable new perspectives. We deeply appreciate our dedicated organizing committee for their tireless efforts and meticulous planning that ensured seamless execution, and our enthusiastic participants whose active engagement enriched the event. Thank you all for making the seminar a memorable and impactful success. Thank you, ma'am. Thank you, everyone.
Thank you so much, guys. Take care. Bye-bye.